The final hearing before George Zimmerman goes to trial Monday is now entering its fifth hour. Both sides have been going back and forth debating the admissibility of scientific analysis of voices heard on the 911 calls. Now, the state wants to use an expert who says Trayvon Martin is heard screaming on the 911 audio. The defense says the technology is not conclusive. This morning, a prosecution voice analyst testified the screams on the tape are not Zimmerman's, but the audio he analyzed was a redacted version from a local newspaper and not the original in possession of the state. He said he compared the audio to publicly available samples of Zimmerman's voice.
The screams don't match at all. So that's what tells me that, okay, it's not George Zimmerman of the screams that I presented.
And I think you said you didn't make a determination as to who it was. You made a determination as to who it did not appear to be.
That's correct.
Joining me now, NBC's Ron Mott in Sanford, Florida. And Ron, when are we expecting the judge to make his decision here on these on this key evidence?
Well, we do expect that she will make a decision, Tamara, at which point she's heard all of the voice experts that both sides would like to have in this trial. We've not heard yet from the one expert who has made perhaps the most declarative conclusions about who's speaking and who's yelling on that 911 call. That's Alan Reich. We're expecting maybe he will come up here this afternoon. The judge says she would be happy to extend the court session into about 6 o'clock today. But one of the distinctions you just heard that the state was making there was that this particular witness who was on the stand this morning, Tom Owen, says that he can say with relative probability that George Zimmerman's voice was not the voice heard in the screams. He's not saying that that was Trayvon Martin. He is saying it is probably not George Zimmerman. Now, the defense really hammered him hard on a specific evidence when he tested these samples that he had, that they did not reach what is generally now, I guess, considered the standard in the industry of 16 seconds in length. He's got a clip that is far shorter than that, and also the standard is about 20 words. He's got far fewer words than that. And the defense is asking, well, how do you then get this software system that you used to basically give you the okay that says that a much smaller sample size can reach the conclusions that you've made? And they got into a little back and forth, and then the state objected. The judge eventually said, you're going outside perhaps the Fry hearing. The hearing today is all about determining the methods that are used, not so much the conclusions that these scientists are making using those methods.
Ron, of course, Zimmerman's accused of second-degree murder. He's pleaded not guilty, claiming this was self-defense. But we know another part of this hearing on the final day, the judge has to decide and consider, and we talked about this yesterday, some key words that, like profiling, for example, but also the kind of dress that people can wear in the courtroom.
Well, yeah, I mean, there's still some motions that have yet to even be introduced today. We don't know how they're going to get to them. Perhaps the judge is going to have court tomorrow. But that particular defense motion is to try to eliminate from the trial some of those what they consider highly charged words that may not be favorable to George Zimmerman, as you mentioned, profiling, wannabe cop, things of that sort. They don't want that introduced in front of a jury because they believe it may imperil their client's chances at getting a fair trial. So still a lot of stuff to go. I mean, obviously this voice testimony is going to be very critical to the case, and we do have one witness yet to go who is probably going to chew up several hours, I would imagine. Yeah. So who knows whether we get this done today or not.
Yeah, so that other motion, though, is whether to ban clothing featuring Trayvon Martin's picture or support for him in the courtroom.
Well, I mean, I think obviously the gallery is a part of the process here, and I think what the defense is asking in that particular motion is that the jury is not sort of colored by the dress, the attire, the gestures that are made by people in the gallery, and so I think they want to make sure that the decorum of the court is held up to a certain standard, and that includes the public and the media in the gallery.
Okay, all eyes will be on that courtroom for certain on Monday. Thank you very much, Ron. Let me bring in criminal defense attorney John Burris. We should note George Zimmerman has sued NBC Universal for defamation, and the company has strongly denied his allegations. John, so let me play a little bit of this back and forth today from the prosecutor and Tom Owen, saying it's common for scientists to have differing opinions on voice, on whose voice, I should say, may be on that tape. Let's play it.
Mr. Owen, as far as the conclusions you reached, is it uncommon in your field for scientists to disagree as to their opinions of what evidence may show, even if they apply, generally speaking, the same types of methodologies?
Yes, they do disagree.
So obviously, John, we know this. We've seen this before in cases where you have experts that are looking at the same thing and see it very differently. That's why you have the state's witnesses or the defense witnesses who come in and try to be the most persuasive to the jury or the judge.
And that's actually true. And frequently, these expert witnesses cancel each other out. You know, they each come from a different perspective, and they will give different opinions. And frequently, jurors have to wade through those. And my experience is that they frequently cancel each other out.
It's interesting regarding this expert who analyzed the voice that he had a redacted version from a local newspaper and not the original in possession of the state. He said he compared the audio to publicly available samples of Zimmerman's voice. There's also some discrepancy on the length of the tape, what is needed to adequately determine whose voice it is. What are you thinking here? Will the judge allow this to be
I think
heard?
with that, if the methodology they used was scientifically reliable, then it's just a question of weight. How much weight do you want to give to that person's testimony, but not that he can't testify. I mean, obviously, he used a methodology that some think, and that will often case, and so it's really not a question of admissibility from my point of view. It's a question of how much weight, and the weight that you want to give to it, that is the believability. That's something the jury gets to decide.
Okay, so Monday, this is the beginning of jury selection here, and we will know, as I understand it, between now and perhaps Sunday, the judge's decision on these defense motions. But as we get to the heart of this trial, what at least is on your mind? What do you expect down to the jury selection? We've seen this before. Who will end up the jury and their backgrounds?
Well, the jury selection is going to be a very challenging effort for both sides, largely because there's a lot of strong feelings on both sides of these issues, and so lawyers will have to try to wade through those. Not so much that they haven't heard about it, but the question is, do they have the kind of opinions that they cannot set aside and view the evidence? This is going to be a real challenge for both sides, because
the racial composition will also be a huge challenge. We know that.
Racial composition will be one of the aspects of it, and there's always a question of whether the defense is going to knock people off just because of their race, and so there's federal law that prevents that from happening. And on the other side of it is the prosecution is going to try to find people who are also biased, if you will, toward the prosecution. So jury selection in this case is going to be a real challenge. The issue is, can you find 12 people who can put aside their strongly held positions and reach the decision based upon the evidence? That frequently can occur. I've been in high-profile cases. No matter what, you can, in fact, do that.
Wow. John Burris, thank you very much. We will have continuing coverage of George Zimmerman's trial for you, and, of course, on News Nation, we've got it covered for you. Thank you very much.